Good morning.
And may it please the court, my name is Margaret Dodson. I'm with the law firm of Bassbury & Sims, and I'm here today on behalf of the petitioner appellant, Greg Lance. I'd like to reserve 4 minutes for
Are you
rebuttal.
nervous that your parents are watching?
She was until you brought it up.
I'm honestly more nervous that your honors are watching, but I'm frankly really honored that they're here and that so many people here are here on behalf of Mr. Lance. Your honors, Greg Lance has spent more than a quarter of a century in prison for crimes he did not commit. He has maintained his innocence this entire time, and the lower court committed reversible error in denying Mr. Lance's quorum nobis petition in the face of overwhelming evidence of actual innocence. I'll submit that your honors will most likely never see again a set of facts that so plainly establishes a petitioner's actual innocence. 5 consistent murder confessions from the same people on the one hand, and a purely circumstantial case against Greg Lance, who is serving life in prison, on the other. This case is the exception. It is why our state law allows for equitable tolling and quorum nobis relief. And under Tennessee law, Mr. Lance is entitled to equitable tolling, and his petition succeeds on the merits. The lower court's holdings are contrary to the laws of our state and cannot stand. Your honors, in 2024, we filed a petition for writ of error quorum nobis, seeking a new trial for Mr. Lance. And we based that petition on what has really become a chorus of consistent evidence in support of his actual innocence. Our petition included sworn affidavits from 3 new witnesses that tell a consistent story that Sam and Peggy Horn, the victims' neighbors, and not Greg Lance, killed the victims and burned their home. One of these witnesses is Sam Horn's own son. And these 3 witnesses now join 2 prior witnesses who have also testified under oath, but never before a jury, of the Horns' confessions and guilt. So in all, our petition included sworn testimony from 5 witnesses that the same people, Sam and Peggy Horn, confessed to this murder and arson.
Now, Mr. Horn, Sam Horn, is now deceased. Is that correct?
Yes, Your Honor.
I don't recall reading anywhere in the record about her current situation.
Peggy Horn, at least last we checked, is in Alabama, Your Honor. She's still alive.
She's still alive.
Yes, Your Honor. In addition to these 5 confessions, one of the new witnesses also explained for the first time how Sam Horn used his nephew to dispose of the murder weapon right down the road from the crime scene, exactly where it was found. We have also included an affidavit from another new witness, a local pastor, who testified that he received and found a shirt at the victims' homes in the days following the murders. That's consistent with earlier testimony never presented to a jury that Peggy Horn left a shirt behind at the crime scene. And we presented DNA evidence that another man's DNA, not Greg Lance's, was on the murder weapon. And then we presented that exact same evidence to the quorum nobis court in a hearing last July. And yet, against this truly overwhelming evidence of actual innocence, the quorum nobis court denied our position, and it held that the evidence I just described, even if it is true, even if all of it is true, did not establish evidence of actual innocence to entitle Mr. Lance to tolling under Clardy. Respectfully, Your Honors, if 5 murder confessions from another person do not establish innocence, then nothing will. That holding really flies in the face of any definition of actual innocence and certainly Clardy's. And then the lower court went on to apply the wrong legal standard on the merits to hold that the evidence presented at the hearing did not entitle Mr. Lance to a new trial. There is no authority in our state that supports these holdings, and so I am here today to ask this court to apply our state's existing law under Clardy and under the quorum nobis statute and reverse. With Clardy, our Supreme Court in Clardy reaffirmed that equitable tolling exists for certain quorum nobis cases. It could have done away.
May I ask you one other question, though?
Of course.
Because I thought there was a reference in here that the trial court said, or the error quorum nobis court said, this court does not find petitioner has demonstrated how the newly discovered evidence, had it been admitted at trial, may have resulted in a different judgment.
That's correct, Your Honor. So that's on the merits piece. So
I know, but he said that. So with regard, so is that technically different than what you're saying that the judge said with regard to actual innocence?
yes, Your Honor. So our petition first takes issue with the equitable tolling issue, which is an actual innocence standard under Clardy.
Okay.
And then our petition takes issue with the quorum nobis court went on to conduct a merits analysis. And in that analysis, it applied an actual innocence standard. And you can just look at the opinion. It says, you know.
So the language with regard to may have resulted in a different judgment, when was that language used? Was that in the trial court, or the trial court?
Yes, Your Honor. It's used in the merits portion, but it is not what the court actually did on application. So our abuse of...
So he said it, but he didn't use it.
Exactly, Your Honor. So,
Okay.
you know, we have an abuse of discretion standard that says the lower court has to apply the correct standard. And so when you look at the courts on the merits, so again, I'm sort of past equitable tolling now on the merits. When you look at what the court did, it took just a couple of pieces of the evidence, and it said the new DNA evidence standing alone does not establish actual innocence. And then it said Keith Penson's testimony about the recovery of the shirt standing alone does not establish actual innocence. And then it just says sort of, as a result, it may not have resulted in a different outcome at trial. So, you know, our law on abuse of discretion is you cannot apply the wrong standard. And here the application is wrong. The inputs are wrong. You can see that from the court's own opinion.
So the judge also made a credibility determination with regard to the witnesses, and obviously declined to determine that they were credible. So how does that fit in with your argument when the judge makes that determination?
Well, there's a couple of really important pieces to that argument, Your Honor. First, and again, this is on the merits, the court did credit testimony from Darren Dunn, one of the witnesses, as to the story. I believe the quote is the story regarding the removal of the gun and where it was found. And that's a really critical story, because that story in it includes a murder confession from Sam Horn. So, you know, that story says, you know, and the court credited that because it said it was corroborated in the record by where that gun was found. And so the evidence that was credited, I mean, here's an excerpt from counsel. Why did Mike tell you, what else did Mike tell you about the circumstances as to why Sam told him to get rid of the gun? Answer, because he killed the people across the road. So, I mean, that's the evidence that's credited. And then the court, frankly, in its analysis below, didn't ever reference that evidence in terms of how it would actually may or may not have impacted the trial court, the jury's determination. So, I mean, to begin, the evidence that was credited is enough to grant relief under the merits, Your Honor. Because when you look at the standard, the may have standard, and when you look at the jury instruction here that required the jury to find, because it is a purely circumstantial case, required the jury to find to a moral certainty that the accused and no one else committed this crime, when there's credited evidence of a murder confession, when there's credited evidence that says, here's why the murder weapon ended up on the side of the road, here's how, here's when. I mean, that's incredibly compelling evidence and certainly satisfies the may have standard that our legislature gave us. And so when the lower court went through and said this individual piece of evidence, you know, standing alone didn't establish actual innocence, that was the wrong standard. And then when it also ignored this incredibly exculpatory evidence of innocence that it credited, that was also a misapplication of the law. And so it violated and abused its discretion sort of in multiple places. We do make, of course, arguments on the credibility determinations below, and I think I think our briefing is pretty robust on that in terms of, this is not a situation where there's anyone else who has said that anyone else has confessed to these crimes. This is not a he said, she said situation. There's 5 people that said Sam and Peggy Horn did it, and there's 0 that say Greg Lance confessed to this crime. So we do believe the credibility determinations are in error, but even on what was credited, on the merits, that's certainly sufficient to establish relief.
Did any of this alleged newly discovered evidence arise before Sam Horn's death? I think it's Horn, right? Yeah.
So obviously the confessions were before he died. He confessed before he died, but we did not, and Greg Lance's team did not learn about any of them until really beginning with this Sundance TV show that caused Tim Horn to come forward. And so the discovery of these witnesses was all well within the 1 year sort of timing requirement for filing under Clardy. And I do just want to go back to Clardy for a minute, because I think that's sort of where the trial court, the lower court's analysis begins, right? And just again reiterate that the Clardy standard is clear and convincing evidence of actual innocence, which means that no one else, but it means nothing other than someone else committed these crimes. And certainly that's what our evidence in our petition shows. And again, Clardy tells us to take that new evidence as true, to take these confessions as true, and credit them at the equitable tolling stage. And the trial court or the lower court goes on and says, that somehow this language, these confessions, this new evidence is vague or uncertain, right, under Clardy. And I just want to be very, very clear that nothing here is vague or uncertain. These confessions, this evidence in our petition fills really critical gaps and tells a really terrible story as to what actually happened to the victims in this case. And this is all from the evidence that needs to be credited as true. How Peggy climbed in to the victim's home through a window and let Sam in, how the Horns killed the victims, how they killed them because of a property dispute, how they shot the victims with a gun with a flashlight taped to it, which is the exact murder weapon in this case, how the Horns burned their home, how Peggy Horn spilled gasoline on herself and almost set herself on fire, burning the house down, how Peggy Horn left evidence behind, how Sam Horn directed his nephew to dispose of the murder weapon, how his nephew did what his uncle said. A jury has not heard any of this and taken as true. It's absolutely evidence of actual innocence under Clardy to move us to a merits determination. And we've already discussed, I think, the abuse of discretion issue on the merits, sort of this misapplication, the application of the incorrect standard, and this court has repeatedly reversed lower courts for failing to apply the may have standard that was articulated by our legislature. That's Freshwater, that's Lowry, that's Johnson, actually twice. And we've cited those cases in our briefing and have talked about them there. And we've also talked about sort of this issue with Darren Dunn and this murder confession that the court even failed to consider. So on the correct standard, on a de novo review, which is once we've established that this was an abuse of discretion, right, that the wrong standard was applied, there's no question that Mr. Lance is entitled to relief. And the state has acknowledged, as it has to, that it has a purely circumstantial case. And so I just want to go back to that jury instruction, which I think is just critical to keep in mind as we consider the proper merits question of whether this new evidence may have made a difference at trial. And it reads, before a verdict of guilty is justified, the circumstances taken together must be of a conclusive nature and tendency leading on the whole to a satisfactory conclusion, producing in effect a moral certainty that the accused and no one else committed the offense. The Coram Nobis court credited testimony that Sam Horn confessed to these murders.
So, and I'm sure know the answer to this question. It's not been, I know that the Supreme Court has changed that instruction. So it no longer is there that requirement that this person and nobody else committed the crime. So if your client were granted a new trial, perhaps, what would the instruction be? Would it be the instruction that was in effect then, or the new instruction, or do you know?
I'm not actually sure what the current instruction is, but in terms of the review of may this have resulted in a different outcome, it's the instruction that the jury was instructed on at the trial. And again, Your Honor, I mean, the Quorum Nobis court has credited testimony of these confessions and of the instruction to sort of as to how to dispose of this murder weapon. And that corroborates testimony from 2 other witnesses who have never testified before a jury as to these same confessions. Justice Koch in Harris has told us that a defendant seeking Quorum Nobis relief can proffer a third-party confession to prove that the crime for which he was convicted was committed by somebody else. I mean, of course he can. And here, the jury was instructed that to convict, it must find to a moral certainty that no one else committed these crimes. And there's no way that it could make that finding with this credited evidence. Your Honors, the Quorum Nobis court's opinion is riddled with reversible errors, and it cannot stand. It is working the gravest injustice against Mr. Lance in keeping him locked up in the face of overwhelming evidence of his innocence. In our state law, equitable tolling and the Quorum Nobis statute exists for this case for the extremely and extraordinarily rare exception to the finality of criminal convictions. And as a result, we're requesting that this court vacate and reverse. Thank you.
Good morning. May it please the court, Lacey Wilbur on behalf of the state. Your Honors, I hate to disagree with Ms. Dodson with her parents in the audience, but such is the nature of the job. And we asked this court to find that the trial court did properly deny the writ of petition for error quorum nobis because it was untimely and there was no equitable tolling. I'm going to just put these in 2 separate spots. So there's the equitable tolling, and then if you get to the merits. And I think the reason why we even got to the merits is because the Clardy opinion came down on June 24th. On June 28th, the Friday before the hearing, the state filed a notice of supplemental authority and said Clardy has come down and said this is what it is. And the court said, no, we're going to have this hearing because experts are here. So that motion was on Friday, and they had the hearing on Tuesday. And I think that is why the trial court went through and did the merits. But on the equitable tolling, the trial court got it correct. And on de novo review, this court should find that that was correct. And under Clardy, the high court said that you do not view the petition in a vacuum. You look at the facts presented at trial. And I just want to present really quickly, I know your honors have read this, but the trial evidence showed that the petitioner solicited 3 separate people to murder the victims. The victims were foreclosing on the petitioner's property in bankruptcy court, and 3 days before the hearing, the victims were murdered. The petitioner was seen on the Heron Farm doing target practice 3 days before the murders. TBI found bullets at the scene that matched the murder weapon. 2 witnesses identified the green cord found wrapped around the murder weapon as green cord that the petitioner had on a swing in his front yard, and 1 witness testified that the flashlight that was tied with the green cord came from the petitioner's truck. And there was also, these victims were burned after they were shot and their house burned. And there was gasoline on the petitioner's shoes and socks, and the petitioner's hair was singed on his hands. And also, he had access to the Heron Farm as he was doing target practice. There were 2 cans of gasoline at the farm in the days leading up to the murder, and 2 witnesses saw these cans. They kept checking on the cans, and then 2 days before, the night before the murder, the cans disappeared. So all of this evidence was presented at trial. And the petitioner for 25 years has been trying to pin this on Sam Horn. In his motion for a new trial, right after trial, he alleged ineffective assistance of counsel because his trial counsel did not call Chris Henry to testify and say he heard Sam Horn threaten to kill the victims because he was manufacturing meth, and they told him to stop it or they would turn him into the police. And the trial court said that's not enough. That's not enough. Hearsay is not enough. And it cited the Newsom opinion and said hearsay alone is not going counter to actual evidence, which we have in this case. We have in post-conviction, the petitioner said, I'm sorry, I'm struggling for words right now. He said Billy Cleghorn didn't testify, and he would have said bad things about Sam Horn. And again, the post-conviction court denied it and said, no, the evidence is that the petitioner did it. And this court affirmed both on direct appeal and on post-conviction. And so you look at that, and then you look at the newly discovered evidence. The newly discovered evidence is not Sam Horn writing, I committed these murders, and I alone acted and murdered these victims. The newly discovered evidence is hearsay. And the Coram Nobis court properly said, this does not clearly establish that the petitioner is actually innocent. And for those reasons, the lower court denied and said there was no equitable tolling because there are other reasons that he could have acted in concert. And just to hop around a little bit, I think somewhere in the record, because I've read it, trial counsel said he did not want a jury instruction on criminal responsibility. So we've been raising the specter of someone else has done this since the trial court. And again, the Coram Nobis court in this case properly denied as being untimely. And if you have no questions on that, I'll move to the actual merits of it. And the lower court did not abuse its discretion when it found that the petitioner had failed to meet the extraordinary remedy of a Coram Nobis petition. And again, the trial court was there, saw the witnesses, and found that most of the witnesses were not credible. They were drug users and they had troubles recalling things. The petitioner's son, Mitchell Horn, testified, and he could not even remember if he had convictions for theft, and he conveniently forgot that his dad manufactured meth, so the trial court did not credit him. The trial court did credit the person who heard double hearsay that Sam Horn told his nephew to go dispose of the gun, and that he disposed of the gun, but the lower court said, this is common knowledge that this is where the murder weapon was found. It was found on the Bohannon property. And again, we're talking about 25 years after the fact. And again, as Clardy said, as time goes by and as the petitioner exhausts the remedies to him on direct and collateral attack, the state's interest in finality of a verdict gets weightier and weightier. And here we are a quarter of a century later, and the state interest in finality of the judgment is very weighty, and the petitioner has not overcome that. I want to make sure I get to everybody. The Derek Helms, again, he said that Sam and Peggy, the wife, had gone to the victim's house and she had messed up, and that Sam said he had to cover her mistake. Again, there's no abuse of discretion for finding that this was not worthy of the extraordinary remedy of Coram Nobis. I think I've made my point. We agree that on the very first issue on the tolling, the petitioner has failed to meet the equitable tolling provision of Clardy, and we will stand on that. And unless this court has any questions on either the equitable tolling or the merits, we ask that you affirm the judgment of the trial court. Thank you.
Your Honors, just, I guess, starting with the trial facts. I mean, again, our briefing goes into this in great detail. It's easy to cherry pick these facts from trial, and we have responses to all of them. But what we're presenting today is 3 new murder confessions, 5 total murder confessions, and evidence as to how the murder weapon ended up where it was found.
And again, none of those people that are affirming that this is what Sam Horn said provided that information before Sam Horn died, correct?
That is correct, Your Honor.
And it's pretty clear, at least from Tim Horn's affidavit, that he doesn't care much for Peggy Horn, his stepmother, as opposed to Peggy Horn, his mother. And so now that's who he's saying that's still alive that killed these people, correct?
Well, he's saying that his dad confessed to killing them, and that he did so with his stepmother, Peggy Horn, but he's not.
Well, they were together. They were both involved in the murder, according to Tim Horn, correct?
That's correct, Your Honor, and according to 4 other people as well. You know, these evidence, these 5 murder confessions, this new evidence from 3 people, all of that is what Clardy tells us to look at, you know, taking this new evidence as true. Yes, of course, the trial evidence is what it is, but assuming the veracity of this new evidence, that is evidence of actual innocence. That is evidence that somebody else, the Horns, did this. That's the point.
The trial court should not have made credibility findings about these witnesses that gave these affidavits.
On equitable tolling, no, Your Honor. But as to the merits, I mean, the trial court is entitled to make credibility determinations, certainly, and our view is that those are in error. But our view is also that those determinations, because of the testimony of Darren Dunn that was credited, but not actually analyzed by the trial court, because of that testimony that was credited, we are still entitled to relief. We have met the may-have standard on the merits that our legislature has given us. So there's sort of obviously the 2 different issues, Your Honor, of Clardy 1, in which the court does not make any credibility determinations. It assumes the veracity of the new evidence. And then the merits determination, which is with respect to the evidence at the hearing. With respect to this criminal responsibility issue, I just want the record to be very, very clear. It is not that our side, you know, denied a criminal responsibility instruction. The state denied a criminal responsibility instruction at trial. It said our position is that Greg Lance and Greg Lance only did this. That's in the trial transcript. So, you know, and there is literally no evidence that Greg Lance knows Sam and Peggy Horn anywhere. So now in the face of this evidence of innocence, the state's coming back and saying, well, maybe it could have been criminal responsibility. That is not this case. That is not what we're litigating. We're litigating new evidence of actual innocence on the standard that, and the charges that the state had at trial.
So you've poured over this record, I'm sure.
I have, Your Honor.
Certainly more than we have. But my memory from reading or taking a look at the original appeal was there was always some cloud of suspicion around the Horns. Is that not true?
That is true, Your Honor. And frankly, that's why I think this is even more compelling, because this has always been his story. His story has always been Sam and Peggy Horn did this, and he just couldn't get the evidence in 25 years ago when he was tried on this. But now we have 5 confessions, and we have hearsay rules that allow us to get these confessions in, and we have Brown, our state's adoption of chambers, that allows all this evidence to come in. And that is why we're here, Your Honors, because we do submit that this case is the exception. It is the extraordinary case that entitles a petitioner to relief under Clardy and under Quorum Nobis. And for those reasons, Your Honor, we just respectfully request, again, that Your Honors vacate and reverse the judgments of the Quorum Nobis Court. Thank you.
Thank you. All right, thank you, counsels. Good briefs, good arguments. Good for another.
Good, thank you.
Call the next case, please.
Christopher Allen Hauser, James